Welcome to the Roetzel Health Law Hotspot. Health Law Hotspot is a podcast for physicians and health professionals that covers the legal issues and trends that affect the healthcare industry.
Hi, everyone. Welcome to the Health Law Hotspot. I'm Ericka Adler, shareholder and leader of our healthcare practice group at Roetzel and Andrus. And today I'm joined by Heather Adams, who's a shareholder in our labor and employment service group. And she specializes in litigating, advising, and counseling clients on employment-related matters. Thanks for being here, Heather.
Thank you. Thanks for having me. Thank you.
And Heather and I have had the opportunity to work together recently on a couple of cases. And I thought it'd be great to have her on to really talk about how employers should handle claims that arise related to discrimination, retaliation, harassment within their practice or their business, and how kind of getting on it right away and understanding what you're hearing and handling it in the proper way can make all the difference. So we're going to jump right in and going to have Heather kind of start us off by telling us a little bit about the type of claims that might arise in a workplace setting.
Sure. And so, from my perspective, as an advisor and a counselor, I kind of hear everything that might happen in the workplace, big and small. And often I feel like employers are more concerned about, how do we respond to a charge of discrimination or harassment or retaliation once it hits the administrative body, which could be the Equal Employment Opportunity Commission, the Illinois Department of Human Rights, the Chicago Commission on Human Relations, one of those formalized bodies. But really, the real work starts when there might be an idea that there's a complaint. And usually what I see happens is someone comes to their manager or goes to human resources and says, I don't like this decision that was made that impacts my life. And it could be, I don't like the fact that I was overlooked for a promotional opportunity. I didn't like the fact that I didn't get this training opportunity. I feel like my pay is not equitable when compared to my coworkers. I don't like the way that my current direct manager is managing me. And so you'll see all those type of claims, but there are particular key words that trigger a different type of response. So of course we want to, immediately look into any complaints that our employees have. But when someone says, I didn't receive the same type of pay that my male colleagues received, now we have something that actually triggers federal statutes, triggers state statutes, and triggers local ordinances. Under the Equal Pay Act, under Title VII, which is a federal statute that prohibits discrimination based on what we call a protected classification. And so when you hear that type of language, it may not immediately resonate with you, but if you are a manager of people or you are in human resources, there is something that must click in your mind at that point that says, hey, we're talking about a potential violation of the law. And that's when you want to talk to your local advisor or have further conversations with leadership about that.
Now, some of the most common ones that automatically get people's antenna up have to do with somebody feeling harassed, somebody feeling that they were discriminated against, or somebody complaining about something and then feeling like they were mistreated as a result of a complaint. And I know some of the common examples I hear might be people making derogatory statements about the background of people working within the practice. And obviously, even if you think someone was joking or you don't think they were serious, you still have to take it seriously, because to that person, they may be taking it more seriously than you are, and you don't know what somebody's going to do or what they're thinking. So you always need to take it seriously. And I try and tell my practices that. I recently had a situation where somebody, felt that people were talking about her behind her back. And so the employer was like, well, have you heard them? Has anybody said anything to you? Have you heard about anything they are talking about, behind your back? She's like, no, but I know they are. Right? So those kinds of things are a little bit harder to act on. But when somebody says, I heard somebody call me this derogatory name, in the kitchen, or somebody told me that was my job because I'm a woman, right? Those kinds of things are much more specific. So I guess there's a little bit of experience involved in kind of asking the right questions to dig in a little bit, right?
And that's exactly right. And, your statements about taking these things serious, regardless of whether there might be, the type of keywords that your ear perks up to hear, is probably your best defense as an employer. And I mentioned employers because the bulk of the work that I do is management side defensive counseling. And so if you have someone who's made a complaint, it is a best practice to thoroughly and promptly look into the allegations and take whatever corrective action that might be. And sometimes you'll look into the allegations, you'll interview people, you'll take notes, you'll do your investigation, and you'll find that it's not substantiated. But the biggest defense that you have is being able to point back to the steps that you took as an employer to evaluate those type of claims to determine whether or not there was something there. Now, let's say that there might be something there, right? So now you have the knowledge and you talk to people so you can take corrective action, whatever form that may be. Right. In egregious cases, that might be termination. In cases that maybe there's a misunderstanding, or maybe there could have been better language used, perhaps, it's a lesser form of discipline. But the point is to complete that investigation and to take some sort of corrective action. The only other thing I will mention there is, that investigation is your best line of defense, because you don't ever want to be an employer or a manager of people that's completely caught off guard or surprised if there is some sort of formal action, right? You should have some knowledge of kind of the way your employees are feeling, whether they've made complaints in the past. And if you've done no investigation, then when you get a charge, you're not going to understand anything that happened prior. You're not going to know why this happened. And that's a bad position to be in if you are an employer.
I agree. And, a lot of people listening to this are smaller practices. They don't have an HR person, right? And it could be the doctor, the dentist, just kind of running their practice on their own. And they don't really know the steps to follow. So I really like what you said, document. I always say, document, interview the person. What are they saying? When did this occur? And keep a timeline of, those conversations, who was present when you had the conversation, right? And then interview the person that they're complaining about. And then sometimes maybe talk to the other people. Did you hear what this person said? They said you were there. Or did you not hear? And then keep it, and then a lot of times they might call me and it'll be like weeks later. Oh, I don't remember exactly when we spoke, or I don't remember who was there. And so I always just keep it. It can't hurt to have too much documentation, but it can definitely hurt to have too little. And then you're absolutely right. When the time comes where I contact you and, an agency gets involved, which we're going to talk about, and the employer's like, yeah, we did talk then, but they don't remember when it was, who they spoke to, exactly what they said. And the memory plays games on us. We don't really remember exactly what was said. And the employee's story can change over time too. And it's really important that that doesn't happen, because, that can, somehow the story always gets worse, right? As time goes on as well. So, for those small employers out there, of course, we're always available, but, as the first line of defense, plan to take a lot of notes and ask a lot of questions, right?
That's exactly right, because time is not on your side. Even if you think it's something small, it's not on your side. And for a number of reasons, all the reasons that you've said, Ericka, are the huge reasons. Memories fade, stories change, but also what if something in the meantime happens? And here's an example. We have an employee who said they're unhappy about whatever the reason is. Let's say they didn't get the promotion. Their manager tells them, you didn't get the promotion because of all of these performance issues that you've had throughout the year. And we've talked about these performance issues throughout the year. And they communicated why they're not getting the promotion. And then all of a sudden, the employee says, well, you know what? Now I have this issue that requires, a disability accommodation. And perhaps you're the employer that was on the disciplinary route, but now we have this issue that intervenes. And if you take any action, there's a risk that the employee might say, oh, well, it's actually because of my disability. That's why it's always a best practice to do prompt investigation, documentation, and to follow up immediately when you find there might be an issue because of intervening activity that might come between the ultimate decision, which may be, not a promotion or discipline, whatever it may be, and this employee saying, oh, well, it's because of this discriminatory reason.
That's a great point. So what happens if an employee doesn't feel that things are getting worked out with their employer directly? Take us through kind of, what employers need to worry about if they're not handling it the way it should be handled?
Sure. First, there is, you use your defense. I will say this. So if you have an employee who has articulated concerns to you as the employer, and you've not taken any action, you've not, interviewed this person or done the investigation, this individual is going to say, if they do choose to file a formal complaint with any of the three bodies we talked about, I'm focused on Illinois, but it could be your local administrative body. They could say, I brought this to my employer and nothing was done. And so from a defense perspective, if I'm defending an employer, I want to be able to look at all the documentation. I want to be able to show not only did we take the employee's concerns seriously, we followed our employee handbook policy for addressing these type of allegations. And if I can't say that, I've now lost that defense, right? That we acted inconsistently with what our policy is. So let's say you have an aggrieved. Go ahead. I'm sorry. Did I cut you off? Okay.
No, right. No.
So you have a person who says, I made this complaint, nothing was done, and now I'm following a complaint with my local EEOC office or the administrative office that handles this type of allegation.
Okay. So how does an employer find out that the employee has taken this step, and what do they need to do, when they hear? And does anybody ever, do they just go all out and file complaints with multiple agencies at the same time, or what do you usually see happening?
So the thing about filing these complaints is it's absolutely free, right? If I was an aggrieved employee or felt I was aggrieved, I don't have to pay anything. I can go on the internet. I can pull up the charge, which is just a form document. I can input my information. I can fax it into my local district office or, email it in. And then an investigator at no charge to me is assigned to the charge to investigate it. As an employer, your first inkling that something's been filed is when the investigator sends you the notice of charge. And that's, really, in my opinion, you should have known that it was on its way. You typically have some idea that this employee may be a little bit more upset than you thought. But if that's the first time you're finding out that there's a problem, we're kind of behind the ball. So you'll get a notice in the mail that'll say that this individual's filed a complaint. And on that charge, they can mark off each area of concern they have. So they can say, if it's me, I feel like I was discriminated against because I'm a woman, I am African-American, I am an immigrant, and of my color, Black. And they check all of that off. And I have a disability. And so then you, as an employer, have to respond in some way. And not only can an individual file it with the EEOC, there is what we call a cross-filing agreement between the Illinois Department of Human Rights and the EEOC, so they can file it with two entities. And then they can decide whether they want the Illinois Department of Human Rights to handle it or whatever state administrative body you have, or whether they want the EEOC to handle it. In addition, you may have something like the Chicago Commission on Human Relations, which is its own separate body without its co-management agreement with the EEOC or the Illinois Department of Human Rights. So that means if I was really upset about something, I can go file it with the EEOC, the Illinois Department of Human Rights, and the Chicago Commission on Human Relations. And you, as an employer, have to deal with all of those investigators. And they are not on each other's timeline, except for the IDHR and the EEOC, but the Chicago, they'll do what they want to do. And if I'm super upset, I can file a wage claim with the Department of Labor. So it's just the opportunities to file something for free are kind of endless.
Wow. So now I know I get a lot of calls when these claims are filed, right? And so a lot of times I'll talk with my client, first of all, check and see if you have insurance for this, because some employers will have insurance and that carrier will assign a lawyer. So obviously you always want to look at that first. In my experience, sometimes they don't have insurance or, to cover $5,000 of the cost, So if that's something you're really worried about, if you have a type of organization where, you got some wild and crazy people who say things that make you worried all the time, get better insurance, right? But otherwise, always check your insurance. And then the bigger question is, should I be using a lawyer or can I just handle this myself? And I know a lot of my clients will, take that first shot and just do it themselves. And then later we're like, oh, we wish you'd called us sooner, because there are some key strategies and words that I know, lawyers like you want to use in response to kind of, mitigate damages, minimize the issues, right? Can you speak to that?
Sure. The administrative body will always say in their notice of investigation that you do not need to retain a lawyer. You can file, you can respond yourself. But here are some of my concerns. When you file a position statement, know that it is not a confidential document, right? The fact that you say at the top it's confidential does not mean that it is in fact confidential. And at the conclusion of the investigation, someone who's savvy enough, like a plaintiff's attorney, can file a FOIA request to request that document. And so anything you've said in your position statement could be an admission against interest, right? And so, in non-legal terms, it means that it could be evidence of a witness statement that's admitted at trial or during litigation that could be held against you. So if you admit something that's not quite accurate or is not really helpful to your position, you can turn and look at those statements and use it against you. And so you need to really be careful about what you say in your position statement if you choose to file one, which is why I always recommend having the assistance of counsel in doing that. Additionally, sometimes you're a segmented organization, and you may not have done a thorough investigation to understand what documents are with what department. So here's an example. You might have a larger organization where managers are able to post and to hire for their own employees without letting upper management know. And so you may have an HR department that has the documents of which they know of, and then you may have hiring managers that have their own files that are separate from what the headquarters files are. And so if you respond and say, well, this simply doesn't exist, or we don't have that, and then you find out the separate arm of your organization has that document, now it looks like we weren't being very upfront and we were hiding the ball. So the assistance of counsel can help you navigate your own organization, determine where and documents are and what documents are relevant to responding. And if I could just talk a little bit about the tools that the EEOC has at its disposal, I'd like to share a little bit about that. So, most employers think I'll send my position statement and that'll be that. The administrative departments have a number of tools that they may use to get the information that they want. First and foremost, I will say that these administrative bodies have subpoena power. So it is important that you be as open and responsive to administrative bodies as possible, obviously while maintaining your own defenses and making sure that you properly respond. They can subpoena documents. They can also do a fact-finding interviews, which means they'll send you a list of people they want to talk to, or a list of department heads that they want access to. And you as an attorney, or me as an attorney, I can help you prepare, but I cannot respond on your behalf. And so now you have an investigator from an administrative body essentially deposing you about this charge. They also have the ability to send a request for information. So they'll say, not only send us your position statement, not only do we want to have interviews of key witnesses, we also want you to respond to this litany of requests asking for documents, org charts, handbooks. So it can be a little bit intensive depending on what the administrative body is kind of focusing on. And so it's important to have the best advice and counsel to ensure that you're navigating that process appropriately.
So when you go through this process, how long does the process typically last? And what kind of outcomes can an employer expect to see? Do they get fined? Can it be resolved in some other way? What kind of outcomes can they expect?
I will say that, and don't quote me on this percentage, but typically, 90% of the claims are going to be resolved without a finding. The EEOC or the Illinois Department of Human Rights or the Chicago Commission on Human Relations will conduct their investigation, and they'll come back and say, yeah, we looked at everything you submitted. We also talked to the complaining party, and we're just not able to say one way or the other whether this happened or not. We're not going to issue an opinion. We're just going to close it out. And then they're going to say, now you, complaining party, have 90 days to file a fulsome complaint lawsuit with either your state court, your federal court, or with your administrative commission. So that's typically how things wrap up. There's no finding. And particularly egregious cases where, there's some really bad fact that just is not helping the employer out. The commission can come back and say, there's substantial evidence that you engaged in discrimination, which you do not want. And so they can take a couple of positions on that. They can find substantial evidence that you've committed this act. And then they can say, we can go into conciliation and try to find a settlement amount that will address the discrimination, or we can sue you at a larger capacity in the name of the administrative body. And so what I mean by that is, let's say they find that you discriminated against one employee, they might think that there's substantial evidence there that you did it to more than that, just that one employee. And so then they will launch their own lawsuit in the name of the administrative body against you, employer. And so now you're fighting the federal government, which, I won't say that's like the normal process, but it happens. And I think it happens more often than we would like, depending on what the priorities are of the administrative body. For instance, back in 2017, the use of criminal background checks was a target area for the EEOC, particularly in Illinois. And so for employers who use background checks, they said you're having a disparate impact on minorities with the use of these background checks, and we're going to subpoena these records. If you don't comply, we're willing to sue you. And if we find that there's substantial evidence with the way you treated this one candidate, we're going to file a lawsuit against you, employer, to see whether you've similarly impacted a larger class of employees. So it's partly what the priorities of the EEOC are, but you just don't want to be caught in the crosshairs, I guess, is the bottom line there.
So in some of our smaller practices, the issues that I see coming up are hostile work environment because of the way superiors are talking to others in the office, certain personnel in the office using discriminatory language. And sometimes it's quite obvious and there's witnesses. In those kinds of situations where a claim is made, do these usually settle for dollar amounts, or is there some other type of punishment that they can mete out other than money?
Other than being sued and for money, that's pretty much the weapons of the administrative bodies. But I think in the smaller cases, let's say we're having a single individual who's filed a hostile workplace action against an employer. The employer can choose to also mediate that. So I don't want to make it seem as the employer doesn't really have a lot of options. So yes, the administrative bodies have their tools to get what they want, right? They can ask you to conciliate, they can ask you to file a position statement, they can sue you, the complainant can sue you, but you as an employer need to take the time to assess. And the help of counsel obviously is a helpful way to assess kind of where you stand, what the good facts of the case are and what the bad facts are. And to give a hard look to see how successful would we be, not only at the administrative level, but how successful would we be if a lawsuit were to be filed? And if there's some bad facts sitting out there, or maybe you think you can get rid of it at a nominal amount, that's a business decision, a very legitimate business decision. Then you could also ask the EEOC or whatever administrative body to mediate it. And that does a couple of things, and I don't want to go too far into the weeds, but there are two arms of an administrative body. There's the mediation side and there's the investigation side. Most employers end up here at the investigation side, but you can stay in the mediation side if you choose that as your route. And really that means coming to the table in good faith, knowing that you're going to hear what the complaining party has to say. You're going to listen. You're going to think about whether, you have a defense to that. And you can say, we heard you. We don't agree. We don't admit to doing anything wrong, but we are willing to put a settlement on the table to not only get rid of this matter for good, but also for you, complainant, not to file a lawsuit against us. So that's a business decision. And so you don't ever have to file a position statement if you choose to mediate. You don't ever have to worry about going to court because you've managed to settle that dispute.
Right. All right, that makes sense. So, for our employers that are out there that are, let's say, a little bit smaller, typically what I like to recommend is that it can cost them more money down the road if they don't handle things properly in their office. So some of the things they can do is to have a lawyer that they can reach out to regularly, to have an HR person in their office or an HR type company that's available to help them make sure they have good policies and to handle that kind of thing like that. So that's, one of the things I recommend. But also just internally, sometimes we say, look, if somebody's, and a lot of times if somebody's been there 20 years, but if they've done something bad, they did something bad, and you're in an impossible situation where if somebody makes a claim, you're definitely going to lose, you may have to fire that person. Right? So being open to doing what it takes to correct it, even if it's unpleasant. Terminating somebody. I also like to do some other types of discipline. It might be, maybe it's an unpaid or paid days of leave, and sending somebody for some kind of training. A lot of times if they're harassing, I recently had somebody ask somebody out or on a date he was a supervisor, asked her out on a date, made her very uncomfortable, and then followed up later in the day and was like, so should I take your silence as a rejection? And that person felt very uncomfortable. So we kind of worked through, and we ended up, that person ended up resigning, and we sent everybody in the office for training, because clearly if the manager didn't know that you shouldn't be asking out subordinates, then our training had been lacking, right? So I guess, what are some alternatives ahead of time that employers should be thinking about to avoid ending up in front of the EEOC? Because I think that's really something our audience could benefit from immediately.
Yeah, my number one recommendation is always consistency, which is easier said than done. And there are a number of tools and resources you can use to ensure that you get consistent outcomes. Because why is someone filing something with the EEOC is always because they felt like they were treated worse than other people. And so we have to have tools built into what we do through the use of counsel, through the use of a robust human resources group to ensure consistent results. And so that has to do with documentation. If you've taken one action or you've made a decision based on certain factors, understand what those factors are, and those factors need to be applied consistently in any other situation that might match that initial situation. Or if you take a disciplinary action against someone, or don't take a disciplinary action against someone, the worst thing you can have is someone say, Joe Schmo did the exact same thing I did. And Joe Schmo not only didn't get disciplined, they got a promotion or something like that. And I was the only person who felt the consequences. It's those instances of inconsistency that expose employers to EEOC charges and to adverse decisions by the administrative bodies. So, working with your human resources to ensure that whatever decision that you make is consistent with policies. If you do not have an employment handbook, you need to get one. And so, that's a separate discussion, but the biggest resource that you have on ensuring consistent results is understanding you have the roadmap about what that should look like. And your employee handbook provides that roadmap, not to every instance or every situation, but really to a good amount of them, right? Ensuring that you know and you document what decisions were made if they're of note. So if you've terminated someone in the past, there should be some record of this termination and the reasons underlying that termination. And if that happens in the future, look back to what you did in the past. So those are, I guess, a handful of suggestions I would offer.
I agree. And one thing about the human resource manual is don't just buy a form somewhere. Make sure you know what's in there and update it. Make it a living, breathing document that reflects changes in your office and things that you decide to do, and review it occasionally so you know what's in there. Because I'm always surprised when employers are, I think we have one somewhere, I don't know what it says, that idea. And then the other thing is, and I know texting is super popular, but that's not a great way to maintain records. So if there's like an investigation or something happened and you documented it and nothing came of it, but 2 years later, you remember something happened, but you can't find anything. It's not in your file, it's not in your email, etc. That you should put copies of stuff in the employment folder for that person or in your electronic folder, whatever it is. And don't rely on text. Like, so many people are like, this is a text of our interview conversation. I'm like, a text, like I maybe I'm just too old now, but text to me is unreliable. You switch your phone, you this, you that, so it goes to your documentation point, but also be thinking about in 2 years, am I going to be able to find this? Am I going to remember, that kind of thing as well. So
exactly. And then one thing I would also add for text, the last thing you want is someone like me during the heat of litigation, filing a request to get all your texts out of your phone and then reading through all of your texts, right? You don't want that. It happens routinely. In fact, I am a purveyor of requests to look in people's phones. And so,
wow.
And if it's intermingled, let's say you have, one text to an employee that might not be that appropriate, then you have something that's relevant to the decision. I'm getting everything and I'm reading through your life. So Ericka, that is such a good point, because people don't, your Slacks, your messengers, your text messages, your Instagram messages, your Snapchats, I want it all. And that's the last thing that you want a lawyer looking through. So that's an excellent point.
All right. Well, are there any final comments that you want to make on this topic? I think we've given everyone a lot to think about here.
The only thing I will say is what I've kind of repeated throughout this podcast is, one, consistency matters, right? It matters to be consistent with your employers. And frankly, if you are an employer of, 2 or more employees, this should be something that you routinely document your decision-making process. 2, prompt investigation. Don't wait 2 days to when, you have time to do it, or a week when you're not busy. And if you are too busy to do it, it's probably a best practice to involve a third party who has no relationship at all to the individuals involved, if you cannot do it. And frankly, there'll be some point where you might not want to be the person to investigate because you're too close to the parties involved. So consistency, promptness, documentation. If you take nothing else from today's discussion, those are the 3 takeaways I would say.
That's great. That is amazing advice. And everybody, if you have questions on this topic or how to handle situations going on in your office, please feel free to reach out to Heather. She's happy to help you. If you come to me, I'll redirect you to Heather and we'll make sure that you're taken care of. So thank you so much for joining us for the Health Law Hotspot. We hope to see you next time, and you can check out more of our podcasts at ralaw.com. Thanks for joining us.
The Roetzel Health Law Hotspot is made available by the firm and its attorneys for educational purposes and to provide general information, not to provide specific legal advice. Use of the Roetzel Health Law Hotspot does not create an attorney-client relationship between you and the firm or any of its attorneys. The Roetzel Health Law Hotspot should not be used as a substitute for competent legal advice, and you should contact an attorney in your state about any legal needs or questions you may have.